Welcome back to Organized, the business law breakdown. This season, we are mastering contracts. I'm your host, Professor Seth C. Orenberg, and today we're diving into the world of contract modification, to the point even of contract cancellation by agreement or assent. Have you ever wondered how parties can change their minds about a contract after it's been made? When you say the ink is dried, you tend to imply that things are final, but what if they change? Well, that's exactly what we're exploring in this episode. Imagine you've signed a contract to buy a house, but suddenly the market crashes. Can you and the seller agree to a different deal, perhaps a modification of the price? Or what if you're owed money and the debtor offers to pay you less, but to pay you immediately? Is that even legal? Today, we'll unravel these questions and more. In our last episode, we discussed when performance was excused due to impossibility, impracticability, or frustration of purpose. Today, we're shifting gears to look at how parties can voluntarily change or end contractual obligations. By the end of this episode, you'll understand contract modification, the pre-existing duty rule, and the various ways parties can discharge or change their obligations through mutual agreement. Before we dive into details, let's put three key takeaways at the top of your mind. The pre-existing duty rule is a traditional rule that requires new consideration for a contract modification. And modern courts have relaxed the rule, so we have to understand how it's changed to a new, lower standard. Accord and satisfaction is a concept about how parties can settle debts for less than the full amount owed while keeping the old obligation alive. And novation and assignment are different ways that we can replace parties to a contract and transfer rights for obligations. By the way, I'll throw delegation in there too. So we'll learn about novation, assignment, and delegation as three different ways to get other people involved with deals. If you've ever been curious about how contracts can evolve after they're signed, or how parties can get out of their obligations without breaching, stay tuned. We're about to do a deep dive into the world of contractual modifications and discharges. Let's start by breaking down some key concepts in contract modification and discharge by assent. Contract modification refers to changes made to an existing contract by, typically, the parties. While it is possible to judicially modify a contract, here we are focusing on modification by the parties themselves. And traditionally, the rule known as the pre-existing duty rule required new consideration for any modification to be valid. This was meant to prevent coercion, or what is known in economics as a hold-up game. Traditionally, courts held that a promise to do what you're already legally obligated to do can't be consideration for a new promise. And again, this is known as the pre-existing duty rule. For example, if you owe someone $100 and they agree to accept $90 as full payment, this agreement might not be enforceable because you were already obligated to pay $90 plus $10. However, modern courts have relaxed the rule, recognizing sometimes modification can be fair and beneficial to both parties. In fact, it's allowed where it is fair and reasonable. Accord and satisfaction is a particular method of replacing an old claim, and it typically works in the debt context. So going back to that situation where someone owes you $100 and you agree to accept $90, the agreement to accept $90 is called an accord. The accord is the new agreement. And satisfaction is whether that new agreement is performed or executed. So if you actually get the $90, the accord is what we call satisfied, and that actually terminates the original obligation. But what if you don't get paid back? What if you don't get the $90? Well, the reason why we call this an accord and satisfaction instead of a contract modification is that old promise to pay $100 is still alive and available. So if you don't get $90, you can sue for the $100 because that old obligation wasn't modified. It was just suspended by what this accord does. And this unique feature of suspending but not terminating the old claim until the new one is performed is the hallmark of the accord and satisfaction concept. And once again, it comes up in most cases regarding a debt that you pay less or something different than the amount originally owed. Novation occurs when a new party is substituted for an existing party in a contract, and all the parties must agree to the change. A novation, again, is an entirely new party who takes the place of an old party in terms of both their rights and their obligations. Novation is different from assignment because assignment is one party transferring just their rights in a contract, just their benefits, if you will. And a delegation is where you transfer just your obligations, just your duties. And so a novation is when you transfer both, completely taking the old party out of the contract. Whereas an assignment, again, keeps the old party's obligations, but puts a new party to receive their rights. And a delegation means a new party is performing the obligation and the original party retains the rights to the benefit. Rescission is a mutual agreement to cancel, basically unmake, also known as void, a contract. And the idea of rescission is that both parties mutually agree to tear up the entire contract and therefore release each other from both their obligations and any rights that they have. And when this happens, the tearing up of the contract is typically consideration. Both parties get something from the tearing up of the agreement. What do they get? They get released from their own obligations under that contract. And so the release of the obligations of one party is consideration for that party's release of the other party's obligations. And so we typically find consideration where we have a rescission unless the contract has been performed fully by one side and not the other. That's a bit of a different situation because the party that's fully performed doesn't get anything from the rescission, and so it would lack consideration. And in those cases, we do have to consider whether the pre-existing duty rule applies or whether some relaxed version of it applies. Our final term before we break it down is release. Release is a unilateral act, and so we'll distinguish release from rescission because rescission is mutual, right? Rescission is where the parties mutually agree to cancel the contract. A release is a unilateral act where one party discharges the other from their obligations. And once again, we're going to need consideration in those cases, and we may not find it very easily. A party does need to receive some consideration for release, or the courts may take a relaxed version of the pre-existing duty rule and release parties where it is fair and reasonable under the circumstances. Look, these concepts are a little fluid, but I want to reiterate that we have some key terms that we need to use accurately in law. So we're talking about modifications, the pre-existing duty rule, accord and satisfaction, and that is one phrase, accord and satisfaction typically comes together, novation, assignment, delegation, rescission, and release. A lot of concepts for today, but let's break it down with a case that helps teach us what the pre-existing duty rule means. Let's take a trip back in time and over to the West Coast to visit the case of Alaska Packers Association versus Domenico. That's a case that taught us the strict version of the pre-existing duty rule. Although this rule isn't the law in most jurisdictions anymore, at least for your run-of-the-mill contract modification, it teaches essential foundations for understanding how courts approach modification and why they may require either consideration or proof it's fair and reasonable. So here's the story. Alaska Packers hired a group of workers, sailors, to sail to Alaska and perform seasonal labor, namely fishing for salmon and packing it as well. The workers agreed to a fixed wage in their initial contract and a certain amount per fish. But once they arrived in Alaska, they refused to work unless the company effectively doubled their wage. Since this company was stuck in a remote location during a brief season of fishing with no other laborers available, and their choice was to lose the profits of the season entirely, the company reluctantly agreed. And by the way, there's a little more to the story. Some say that the conditions the sailors found themselves in were much worse than expected, like the nets had holes in them and so it was hard to catch fish. The court didn't buy this, by the way, so we're not going to use those facts in understanding the case here, but it is kind of interesting. There's always arguments on both sides. In any event, the season ended, and the workers went back to San Francisco and demanded their higher, almost double wages. The company agreed to pay them the original amount, but not the double amount, arguing that the new agreement, the modification, wasn't enforceable. So the question here is whether the modification was enforceable. And again, the parties did agree to it. Well, the court sided with the company, Alaska Packers. And why? Because of the pre-existing duty rule. The pre-existing duty rule holds that contract modifications require new consideration. And it asked, what is new about the sailors here? The sailors had already promised to fish for Alaska Packers. What new thing were they doing? Nothing. Nothing new. They were only promising to do what they had already promised to do. They were promising to fulfill a pre-existing duty. And that's not consideration, and therefore the modification is invalid. The court kind of read modification to be just like another type of contract. Just as contracts require consideration to be enforceable, so do modifications, at least under the older, stricter version of the pre-existing duty rule. Under the strict version of the pre-existing duty rule, a promise to do something a party is already legally obligated to do is not valid consideration for a new agreement nor a modification. So, the workers in Alaska Packers were already bound by their initial contract to perform the labor. Their refusal to work was effectively a form of economic coercion. The company had no real choice but to agree to their demands, and therefore the modification was unenforceable and, under doctrine, invalid for lack of new consideration. It is kind of interesting because we could look at other doctrines like economic coercion, but here the court stuck with the consideration doctrine. And this decision reflects a rigid and somewhat formalistic approach to contract modifications, one that is a bit outdated. The court prioritized the original bargain, emphasizing that modifications should not arise from undue pressure or one-sided demands, but it didn't really look at whether there was pressure or one-sided demands. It just looked at nominally whether there was new consideration or not. Here's the thing. The strict version of the pre-existing duty rule doesn't dominate modern contract law, and we can even see the flaws in it when we read the Alaska Packers decision. Courts and legislators have recognized that sometimes fair modifications are necessary, especially when circumstances change in unforeseen ways, and that's where the doctrine of good faith and a more flexible approach, which is found in cases like Angel versus Murray, which we'll break down later in this podcast, come into play. Still, Alaska Packers provides a crucial historical foundation because it shows us the importance of consideration in contract law. Courts are wary of enforcing modifications because they could be made under duress. Once the parties are in a contractual relationship, they have a duty of good faith and fair dealing to each other. They're not just strangers anymore. So there's also some special relationship that arises out of the contract. And for these reasons, we are cautious about the exploitation of bargaining power in a way that undermines fairness and the doctrine of mutual assent. So while the pre-existing duty rule might seem a little bit like a relic of the past, and where it isn't strictly followed, its legacy and its purpose lives on. It had a little bit too many false negatives and false positives in the sense that on the one hand, there are contracts that probably should be changed and the parties intended to that wouldn't be enforced, and others where if you paid like peppercorn or $1, you would be able to modify a contract that was otherwise unfair. So it wasn't a perfect way to achieve the goals, but its goals, balancing flexibility with fairness, are important. Now let's consider some what-if scenarios. What if the sailors and Alaska Packers had discovered that the fishing conditions were much more dangerous than anticipated? Would that change our view of the fairness of the request for higher pay? Yeah, probably. This scenario would likely change our view of the fairness of the request. If the conditions were genuinely more dangerous than reasonably anticipated, it could be seen as unanticipated circumstances that might justify a contract modification. Under the modern approach, as exemplified in the case we'll read next, Angel v. Murray, courts might consider this a fair and equitable reason to modify the contract. However, the sailors would need to show that the increased danger was truly unforeseen and not just a normal risk of their profession. What if a construction company agrees to build a house for a set price, but halfway through, the cost of lumber skyrockets due to an unforeseen global shortage caused by COVID-19 and resulting government shutdowns? Should they be allowed to renegotiate the contract and get a higher price? Under the modern approach to contract modification, this scenario might justify renegotiation. The global shortage, the government shutdowns, and the skyrocketing cost of materials could be considered an unanticipated circumstance that makes performance significantly more burdensome. And if the increase in costs is substantial and truly unforeseen and unforeseeable, a court might view a modification to the price as fair and equitable. However, the construction company would need to show the price increases went beyond normal fluctuations, that they shouldn't have reasonably anticipated or protected against this, and that the amount that they have charged in response, again, is fair and reasonable in light of the circumstances. What if a small business owner agrees to supply a large corporation with goods at a certain price, but then realizes they'll go bankrupt if they follow through on their promise? Should the law allow modification to save the small business from being bankrupt by the large corporation? This scenario is more challenging. While the potential for bankruptcy is certainly a serious concern for a small business owner, courts are generally reluctant to allow contract modification based purely on one party's financial difficulties, even if it's a bit of David and Goliath in the storyline. The risk of a bad bargain is typically a risk that businesses take on. Businesses, after all, are responsible for taking on their own risks. And if the small business owner could show that their bankruptcy were due to some kind of truly unforeseen circumstances and not just a modification, now we have some shot at suggesting that the modification to the price is fair and equitable, or the refusal to provide the goods. A court might be more inclined to allow it because of sympathy toward one party or another, but at the appellate level, this might not stick. Remember as well that although bankruptcy seems terrible, businesses are limited liability vehicles. They're designed to prevent the people who run them from going bankrupt when the businesses do. So, look, businesses are a method of taking risk, and they typically are responsible for the risks that they take when making transactions. I'm going to say probably no valid modification in this case, but you never know. If you're in the right court, you might find a sympathetic ear, especially with a local jury. These scenarios highlight why modern contract law has moved toward a more flexible approach. While the pre-existing duty rule is aimed to prevent coercion, strict application can lead to unfair results when circumstances genuinely change, especially in an unforeseeable and unforeseen way. The modern approach tries to balance the need for contract stability with the reality that the unforeseen event can alter the fairness of an agreement, as shown in our next case. Let's break it down again with a modern case and look at Angel v. Murray to dig deeper into why courts are willing to modify contracts. Sometimes it's a win for everyone involved, and the modern approach to contract formation actually makes sense, both practically and economically. So here's the setup. In the mid-20th century, James Mayer had a long-standing agreement with the city of Newport, Rhode Island, to handle, quote, all its refuse collection. By 1964, he entered into a new 5-year contract committing to manage all the city's waste for an annual fee of $137,000. Now, this arrangement was based on understanding of the city's typical growth patterns, and the city typically saw 20 to 25 new housing units each year. However, in 1967, Newport experienced an unexpected surge in development. It added approximately 400 new dwellings in a single year. That's a significant departure from the norm, with 8 times as many houses in 1 year as expected. This rapid expansion led to a substantial increase in the volume of refuse Mayer was responsible for collecting, far exceeding the original expectations. Recognizing the unforeseen challenge, Mayer approached the city council, requesting an additional $10,000 per year to adequately manage his increased workloads. After public hearings where Mayer presented his case, the council agreed to his request, approving the extra payment for that year. The following year, faced with continued high levels of refuse, Mayer made a similar request, and the council again approved it publicly. This arrangement continued until a group of taxpayers, led by Alfred L. Angel, challenged the legality of these additional payments. And by the way, why is the case Angel v. Murray? Because Murray was the chair of the city council. And so Angel actually sued the city council for having violated the terms of the agreement, the original agreement, by paying extra compensation to Mayer, the trash collector. So Angel, who led the group of taxpayers, argued that the extra compensation lacked proper consideration because Mayer had already promised to collect all the refuse from Newport. And what was he promising under this modified agreement? Well, to collect all the refuse from the city of Newport. There was nothing new, so there was no valid basis for modification. This case eventually reached the Rhode Island Supreme Court, which had to determine whether the contract modification was valid under the circumstances. And they determined it was valid. This was a permitted modification as a contract, even though Mayer didn't offer any new consideration. This is a different result than we got in the Alaska Packers case. Why? Because the court found the modification was made in good faith in response to unforeseen circumstances and represented a fair and equitable change. These principles define the modern rule with an express rejection of the classic pre-existing duty rule. To make it clear, the Restatement Second of Contracts in Section 89, if you're following along, states this, quote, "A promise modifying a duty under a contract not fully performed on either side is binding if the modification is fair and equitable in view of the circumstances not anticipated by the parties when the contract was made." So why is this a win-win? Why is this rule in place? Well, it's about adaptability, first and foremost. Contracts, especially long-term ones, rarely go exactly as planned. Circumstances change, and sometimes they change dramatically. In Angel v. Murray, the unexpected population boom meant Mayer's workload was far beyond what he reasonably anticipated when the contract was signed, and also far more than the city expected to get from him for that price. By allowing the modification, the court ensured the contract could adapt to the new reality without breaking down entirely. And it may have been, and was presumably better than, finding an entirely new contract with an entirely different trash collector. This keeps agreements relevant and functional, especially in long-term agreements, and that can be a win for both parties. Second, the modern rule promotes the standard of good faith and fair dealing. When modifications are made honestly and voluntarily, without coercion or bad faith, they represent mutual trust and cooperation. And frankly, contracts are really about that more than they're about rights to sue. Most contracts don't get litigated, and they're still useful because they represent the way parties have agreed to get along and conduct some valuable business for each of them. Look, in this case, the city recognized the fairness, and they did it publicly with hearings. And the city council had no basis for paying Mayer extra money. There was no claim of extortion. It simply was a changed circumstance no one anticipated. Courts value this kind of honest negotiation. It strengthens the relationship between the parties and supports the integrity of contract. Third, and this is crucial, there is an economic argument at play. Let's imagine the strict pre-existing duty rule had been applied and the court invalidated the modification. Mayer may have been forced to walk away from the contract entirely because it was no longer viable for him to perform at the original price. If Mayer left the refuse, the city would have to scramble to find another garbage collector to collect the trash. And likely, given that Mayer couldn't do it at the original rate, at an even higher cost, plus the cost of litigating. That's not efficient. Litigation is expensive, and it's not good for anyone but the lawyers. By allowing fair modification, the law reduces transactions costs and keeps business relations intact, which is better for everyone but the lawyers. Now let's tie this to the Uniform Commercial Code. Under UCC Section 22091, an agreement modifying a contract for the sale of goods does not require new consideration to be binding, as long as the modification is made in good faith. This is the same principle we see in Angel v. Murray. The UCC also recognizes that commercial relationships are dynamic and that modifications are often necessary to address changing conditions. The key, once again, is good faith. Modifications must respect and reflect honesty and fairness, not opportunism or coercion. The modern rule is meant to strike a balance. It doesn't throw the pre-existing duty rule out the window. It doesn't ditch consideration. It builds on its foundation while acknowledging the realities of modern commerce. The pre-existing duty rule taught us the importance of consideration because it prevents coercion and avoids a holdup problem, where parties get into a relationship and then have the ability to take advantage of one another. But as contracts had become more complex and more long-term, the laws evolved to prioritize flexibility and economic efficiency when principles of contract law align with good faith and fair dealing. At the end of the day, contracts are here to make business go. So to recap, the modern rule for contract modification allows changes to be binding without new consideration if they are fair, equitable, and made in response to unforeseen circumstances. This approach benefits both parties by keeping contracts viable, promoting fairness, supporting the realities of modern business relationships, and keeping deals out of court. As we've seen in Angel v. Murray and the UCC, good faith is the glue that holds the modern rule together. This is how contract law evolves. We don't discard old rules entirely. We tend to build on them to address new challenges in a fair and practical way. Let's dive into some pop culture examples that illustrate some concepts of contract modification and the pre-existing duty rule that we've been discussing. In 1969, 2 years after Newport added 400 new dwelling units, the Beatles found themselves in a situation that exemplifies the challenge of contract modification. They attempted to renegotiate their contract with Northern Songs, the company that owned the publishing rights to most of their songs. When negotiations failed, the Beatles tried to buy a majority stake in the Northern Songs company. So instead of being able to change the agreement, they thought they'd just buy the party that owned the obligations the Beatles owed. A classic example, huh? However, ATV Music swooped in and acquired Northern Songs instead, and this led to decades of legal battles over the Beatles' music catalog. It's apparently one reason for years you couldn't listen to the Beatles on Apple Music and several other streaming platforms. And the situation highlights several key points about contract modification. First, the difficulty of modifying existing agreements, especially where large sums of money are involved. Second, the importance of considering all parties' interests in a contract modification. And third, the potential long-term consequences of failed contract modifications. The Beatles case also shows how pre-existing duties come into play, especially with long-term contracts. Things change. The Beatles weren't the same band as where they originally signed with Northern Songs, but Northern Songs certainly wants to profit from the winners that it signs. That's sort of how it works in the record industry. You get a couple duds and a few big stars, and your label makes it. The band was trying to change their obligations under an existing contract, so it relates directly to the concept we discussed. Let's shift to a real-world example for today that brings the same principles to life. Do you recall the high-profile saga between pop star Kesha and producer Dr. Luke? This case isn't just a legal battle, it's a story that rocked the music industry and sparked conversations about artists' rights and power dynamics. In 2013, Kesha teamed up with Pitbull to deliver the chart-topping hit Timber, showcasing her place in pop music history. But behind the scenes, storm clouds were gathering. In 2014, Kesha filed a lawsuit against her longtime producer, Dr. Luke, attempting to void her recording contract. She alleged abuse and unfair business practices, seeking to break free of their professional and maybe personally fraught relationship. Kesha's legal move wasn't just about tweaking contract terms. She wanted to nullify the agreement entirely. This brings us to the heart of contract modification and the pre-existing duty rule. Typically, modifying a contract, in this case, completely modifying it to the point of it not existing, requires some new consideration. Kesha would have to buy out Dr. Luke effectively. But Kesha argued that Dr. Luke's alleged misconduct fundamentally breached the contract's terms, justifying her departure without the need for new consideration. So the case actually highlights several critical issues in contract law. First, artists sign long-term deals early in their careers, which can later feel restrictive. They may attempt to modify these contracts, but producers want to keep them, especially with the winners in the artists that they pick. Record labels would go out of business if they didn't profit from some of their deals, and if all the profitable ones simply got rid of the record labels, that wouldn't be a very good business to be in. The intertwining of personal relationships and professional agreements can absolutely complicate disputes as emotions and business interests collide. The Keisha Dr. Luke dispute involves some real personal stuff, and it dragged on for a decade, which can happen where the parties aren't willing to settle because they're suing for more than just the economics. They're suing to win on a personal level, and those emotional aspects can really drive a litigation to continue. And the case drew massive public attention, with fans and fellow artists rallying behind Keisha. The public support added pressure on legal proceedings, and it certainly influenced negotiations in interesting ways, especially because we saw the advent of the Twitter sphere, now the X sphere, I guess, during this time. This legal struggle stretched nearly a decade with multiple lawsuits and countersuits, and it wasn't just a courtroom drama. It was a public spectacle that kept fans and industry players on edge. In 2023, Keisha and Dr. Luke finally reached a settlement, bringing an end to a long dispute. The saga underscores that contract modification isn't just a dry legal concept. It has a tangible effect on artists' careers, on creative freedom, and financial well-being. And we have to be careful, because although it may seem unfair to keep a person in the deal that they're in, if people could change their contracts readily, there may not be incentives to invest in these sort of things in the first place. So it is a tricky, complicated economic issue. They serve as vivid reminders of the complexities in contractual relationships and the importance of balancing legal principles with the realities of personal and professional dynamics. Let's recap the main points we've covered. 1. The pre-existing duty rule traditionally required new consideration for contract modifications. And 2. Modern contract law allows for fair and reasonable modifications without new consideration. 3. Courts consider multiple factors like unanticipated circumstances, good faith and fair dealing, and substantive fairness of the final results when evaluating if a modification is valid. And 4th, concepts like contract substitution, substituted performance, accord and satisfaction, novation, delegation, assignment, rescission, and release all are different ways parties modify or discharge their contractual obligations. Even though this podcast went longer than most of them, we didn't even have time to get into all those details. And the reason why is I wanted you to understand the main point. Contract modification doesn't require new consideration, but it has to be fair and reasonable. So whatever you call it, courts are going to generally look at it to determine whether the modification was fair and reasonable under the circumstances, which typically must have some kind of unexpected, unanticipated, unforeseen change. I hope you found today's episode helpful as you think about whether you can change deals you've signed. If you did, please subscribe to Organize, the Business Law Breakdown, and leave the podcast a review. Your support helps us continue to break down legal concepts for students and professionals alike. That's all for today's episode of Organize, the Business Law Breakdown. I'm Seth C. Orenberg, and I thank you for tuning in and exploring the fascinating world of modification by mutual assent with me today. Remember, until next time, keep your agreements strong and your arguments stronger.